Yeah, hello everyone. Today's topic is Digital Personal Data Protection Bill 2022. The Indian government is coming with a Digital Personal Data Protection Bill 2022. Now, first we need to understand why this Digital Personal Data Protection Bill has been introduced. First, let's go back to the history. In 2018, Indian government has come up with a data protection bill. A data protection bill. They have come up with a data protection bill. The bill has been withdrawn due to some reasons are there, like there are certain flaws are there in the bill. The bill has been withdrawn at that time. Now in year 2022, they have come up with a fresh uh, data protection bill. The name is Digital Personal Data Protection Bill. Now, first we need to understand why this personal data protection regulation or bill is required. So let me give you a brief related to that, why these things are required. So as you are aware that multiple countries, there are numbers of countries which do have their personal data protection bills and all to protect the personal information. Like if you talk about these things, there are many countries are there like Argentina, Australia, UK. In European Union, they do have their personal data protections regulation that is called as the GDPR. They are calling it as a GDPR, General Data Protection Regulations. In the same way, California do have CCPA, and multiple countries do they have their personal data protection regulation. In India, till now we are dealing with IT Act. We don't have any proper personal data protection bill to protect the privacy, or you can say personal informations of the users. So we are dealing with only IT Act, which for this privacy related regulations. Now the multiple countries do have the personal data protection regulations, but we in India we don't have any personal data protections regulations. So that's why the government has decided they are coming up with a fresh data protection bill, and they are calling it as a digital data protection regulations. Now the first thing is that we need to understand what actually the personal data is, to whom we are calling it as a personal data, because they are calling it as a personal data protection bill. So first we need to understand what actually this personal data is. Those who are new to my channel, uh, they can go, I have the multiple video on this personal information privacy regulations and all. So I will also give the link of those things in my this video itself. Now we need to understand first what actually the personal information is, to whom we are calling it as a personal data. Now personal data means there are certain attributes of the personal data. Now these attributes are like your workplace. If you are working at a workplace, your harassment detail, investigation detail, bullying would be a part of your personal information. In the same way, when I talking about the personal identification, that is called as the PII, personal identifiable information. Your name, your age, your date of birth, your full name, your gender, your height, your marital status, nationality, your photograph, your weight, your signature, your gender, all these things comes under the personal information. Now the question here is your name a personal information? Suppose your name is Anup. Is your name is the personal information? No. Your name itself would not be a personal information. But if I combine with your name with your date of birth, then it is called as a personal information. Now in the simple and plain language, if I have to describe the personal information or the personal data, so those information or data which can identify a person is called as the personal data, or you can say personal information. Now, in the same way, your personal identification informations are there, your professional experiences are there, your social media accounts related details are there, your medical history, your vaccination certificate, your health information, these things also comes under the personal information. In the same way, if I talk about your legal identity, your DL number, your passport number, your Aadhaar card number, your PAN card number, these things also comes under the personal information. Your If I'm talking about your financial details, your bank account number, your bank statement, your credit, if you are using the credit card, your credit card number, your credit history, your debit card informations. When I'm talking about your family, your children's data, your parents information. If you are working professional, then in that case your employment related information, your educational and skill related information, and your contact detail. So all these things comes under the personal information. Now you understand, we have lots of things in the personal information, and in India your contact details, your addresses are very frequently shared with each and every persons without having your consent. Most of the people must have getting numbers of random calls from real estate things, from shopping apps, from many service providers who are calling them, and you are also surprised, boss, I have not shared my phone number or my details to them, even I am getting the calls. So that's why there is a need of this personal information, that your personal information are shared with numbers of organizations very frequently. That's why government is coming up with this digital personal data bill. Now we'll go ahead and see what actually the things are there in the personal data bill, how it's differentiate from GDPR and another personal data regulation. Although the bills it under evaluation itself, the bill has not been passed, because first it needs to be passed from the lower house, it will go to upper house, then it will go to the president, and when the president signs it, then it will become an act in India. Still, it's not bill is under evaluations. The suggestions are being seeking from various platforms or various users, or you can say, if there is any possibility that anything has not been captured correctly, this would be changed. So now it's in the review phase itself. Very soon we do have this bill, but currently this bill has not been approved, or this has not become a law. Now we will understand what actually this bill is talking about. Now the name is Digital Personal Data Protection Bill 2022. So there are numbers of things they have described here, like in the table of contents you can see grounds of processing. The first thing is that you can see here the grounds of processing of digital personal data, how to give the notice, how to take the consents, deem what is the deemed consents, additional obligations for data fraud and all. So rights to some rights have been also given to the user. If you'll see, there are certain rights has been also given to the users related to their personal data, like right to information. The right to information is also right to information about the personal data. Users have rights to be informed related to their personal data. The correction and erasures are also been there. The grievance redressal also is there. The right to nominate, this is the first time in any privacy regulation this has been added. If you have gone through the GDPR and all, these things were not there, but in this digital data protection bill, which is introduced by government of India, this right to nominate has been there. Now, duties of the data principles. Now, there are multiple terms what you are seeing, like your data principles. In GDPR, we are talking about the data subject, data principle. What is this data principle? This is the individual whose data we are collecting. Individual whose data has been collected that is called as the data principle. In the same way, GDPR is calling it as a data subject. Data subject and data principle are the same thing. This is the individual whose data has been collected or processed. Now let's go one by one and see how this personal information, how this bill, what are the things would be there in this bill. Now we will understand what actually there are, this the definition has been given there, like your board, to whom they are calling as a board. Data protection board of India would be established by the central government. So they are going to establish a board, like supervisory authority are there in the GDPR. Supervisory authority are there in the GDPR. In the same way, data protection board would be there in India. Like child, to whom they are categorizing in the child, they are saying those who are not completed 18 years of age. Now in the some of the privacy regulation, it's 13 years. In GDPR they are calling it as 16 years. So it depends country to country, but in India, the child would be considered if you have not completed a age of 18 years. What actually the data means? The data means the representation of information, the facts, the concepts, opinion, or instruction in a manner suitable for communication, interpretation, or processing by the human or the automated means. The processing can be done by the humans, or processing can be done by automated means. That means if you are providing your data to any of the websites or any of the you can say application, the automated processing of the data is being also happening. So this they have categorized what actually the data is means. Now data principle, the individual whose data we have collected, which we have seen earlier. Now data processor, the data processor means any person who processes the personal data on behalf of data fiduciary. Now data processor means who is processing the data. Now data, they have introduced this data fiduciary terms. Now this is the same as in the GDPR, we are calling as the data controller. So this is the same term what this bill is talking about. The data protection officer is the same, like an individual appointed by the organization by a significant data fiduciary under the provision of act. The data protection officer should be appointed by the data controller. So who would be the single point of contact by the data subject related to their query, or they are related to when the individual wants to use their rights. The data protection officer should be appointed by the organization. Now harm, what they are talking about, this harm is any harassment, prevention of lawful gain, or caution of the significant loss, any bodily harm, or distortion or theft of the identity, harassment. So these are the things that comes under the harm. If loss, they have also categorized the loss. What actually the loss means? Loss means the loss in property, interpretation in the supply of the services, where temporary or permanent, or a loss of opportunity to earn remuneration or greater remuneration, or gain a financial advantage otherwise than a way of remuneration. So you can see here the things are correlated with the GDPR. These things are similar to GDPR. The terms are also similar. The persons could be an individual, a Hindu undivided family, a company, a firm, a state or association of the person, or every artificial juristic person. So you can see this, they have categorized the persons as an individual, this can be a company, this can be a firm and all. In the same way, personal data mean the data about an individual who is identifiable by or in relation to such data. In the same way, they have also categorized this data. Now, personal data breach, what actually this breach is? If your data has been disclosed, this disclosure of the data would be accidental or by sharing, by use, by alteration, by destruction, acquisition, in by using any of these means. If your data has been shared by accidentally or someone knowingly share your data and all, these things considered as the data breach. Data breach means loss of your data, or you can say disclosure of your personal information without having your consent. Uh, processing means processing means sharing of your data, sharing, using, storage, adaptation, alteration, or disclosing of your information with any of the person. These things comes under the processing of the information. So this act, the first thing is that this act, application of this act, the provision of X shall apply to the processing of digital personal data within the territory of India. The first thing, that such personal data is collected from the data principal online, or such personal data can be collected offline also. And if it is collecting offline, it would be digitized. So it doesn't mean if the bill is the digital data protection regulation, the only online medium is considered. No, it offline medium is also being considered by this bill. If you are collecting any personal data offline and you are digitizing it, this also would be considered under this bill, and the data should be collected within the territory of the India. That would comes under the scope of this personal data protection, or you can say digital data protection bill. Now, this certain exclusions are there. This act would not apply on offline personal data. If you are collecting offline personal data, you are not digitizing it, it would not be considered. Non-automated processing of the personal data would also not be comes under this scope. The personal data processed by an individual for any personal or domestic purpose. If you are using for your purpose or your domestic purpose, then it also be not comes under this thing, this regulation. Now, personal data about an individual that is contained in a record that has been in existence for at least 100 years. This also would not comes under the scope of this regulation. Now, there are certain things what has been considered, like while processing any personal data, the purpose should be lawful. Lawful purpose should be there. That unlawful data processing would not be considered, or will be considered as the breach of this regulation. So before collecting any personal data, you need to give the notice to the user. The first thing is that if you are collecting any personal information, you need to give the notice to the user. Now, along with notice, you need to take the consent from the user. If you are collecting any personal information, you need to give the notice that for what purpose you are collecting the personal information. Now, once you have given the notice, you need to take the consent from the users, and consent should be freely given. This should not be pressurized. Users should not be, or individuals should not be pressurized to give the consent. The consent should be freely given by the user. So there are certain regulation related to consent is also there, like how you need to take the consent. If you are taking the consent should be recorded. This should be recorded somewhere, or this would be available as a documented information. Now, in sometimes you are collecting the personal information in the public interest. Now, public interest would be like prevention and detection of fraud, for M&A, merger and acquisition related activity, network and information security. You are collecting for credit scoring. You are collecting the personal information, recovery of the debt. Banks are collecting your personal information. So these are the things comes under the public interest. So if you are collecting any personal information for the public interest, these things would be considered as the public incidents. Or there are certain obligations related to children's information, children's personal data. If you are collecting any children's personal data, so the data controller or data fiduciary shall, before processing any personal data of child, obtain a verifiable parental consent. Here you need to obtain a parental consent before capturing or processing the personal data of the children. The children they have categorized below 18 years. The consent should be obtained by their parents while processing the personal information of the children's. There are certain obligations are there to the data controller or data fiduciary, like if you are totally responsible to protect the personal information of the users, if you are collecting the personal data of the user. That bills is also given certain rights to the users, like rights to the information, right to information about the personal data. The data principal to have certain rights, and that right should be obtained by the data fiduciary or data controller, like the summary of personal data, what has been processed, any information as may be prescribed. In one place, the identity of the data fiduciary, with whom the personal data has been shared, what are the personal data you have captured, to whom you are sharing the personal data. So these rights are there with the data subject or data principal. Anytime they can ask from the data controller or fiduciary that how you are processing my personal data. In the same way, right to corrections is also there. Right to corrections is also there. If you feel that your personal information what has been captured is not correct, you can reach out to the organizations, you can reach out to the data controller or fiduciary, and you can ask them to correct your personal information. And also the data controller, data fiduciary have the data fiduciary should correct those data upon the receival of that request. In the same way, you can able to correct your data, you can able to your complete your data if data is incomplete with them. You can also able to update your data. If you want to erase your data, then you can also use this your rights to erase all your personal information what has been captured by fiduciary. In the same way, if we have any grievances, the grievances redundant system should be there. The data principal is not satisfied with the response. All the grievances should be recorded, and the grievances should receive a response within the 7 days. This has been very thing we need to understand. This within the 7 days, the data controller or fiduciary has to respond to the data principal about any grievances if they have received. Here what you need to do, there are various numbers of controls which needs to be implemented by organization related to that. We will come what later on, that what are the control measures that organization should implement to be compliant with this act. Now another right to nominate has been added in this digital data protection bill. The data principal shall have rights to nominate in such a manner as may be prescribed any other individual who shall, in the event of death or incapacity of data principal, exercise the rights of the data principle in accordance with the provision of the act. So this is the first thing what has been added in this digital data protection. New things you can say what we are seeing in various regulations which is available across the globe. This is the new thing what has been added. You can nominate any of the persons to exercise your rights. Now there are certain duties of the data principles. What they need to do: data principles shall comply with the provision of all applicable laws while exercising rights under the provision of Act. Data principles shall not register a false or any fraud grievances or complaints. The data principles shall under the no subcategory, including while applying any document service, unique identifier, proof of identity, address should be furnished. So there are certain duties are also there. There are certain duties are also there which needs to be adhered by the data principle. Now, if we are sharing any personal data outside the India, the personal data which has been shared outside the India, the central government, after an assessment of such factor as it may consider necessary, notify such country or territory outside India to which the data fiduciary may transfer the personal data in according to terms and conditions. There are various terms and conditions has been identified, and according to that, we can send the personal data outside the territory of the India. Now, Indian government is going to form a data protection board of India, like supervisory authorities are there in the various countries, or like in the same way they are coming up with a data protection board, and this data protection board would be responsible for the implementation, or you can say this regulation in our country. So this data protection, any grievance related to data subject or data controller, so we can reach out to them. So they would be in their supervisions, everything would be governed. The data protection board would going to be formed. So there is also financial penalty. This is very much important related to financial penalty. The board determines the conclusion of inquiry that non-compliance by a person is significant. It may, after giving a person a reasonable opportunity being heard, impose such financial penalty as prescribed in the Schedule 1, not exceeding rupee 500 crore in each instance. The penalty should not be exceeding 500 crores in Indian rupees, but they have given that what are the penalty clause in the Schedule 1. So there are huge number of penalties are there. In case of the penalty should not be above the 5,000 crores, but there are penalties are there. Now the thing is that if there are huge numbers of penalties are there, in that case, let's see the penalty, like if the data processor or data fiduciary to take the reasonable security safeguard to prevent the personal data. So if you have not faced proper technical measures within your organizations, that there is a penalty up to 250 crores. If you are failure to notify the board the affected data principal in the event of personal data breach, because you need to also notify to the board if any data breach has happened, then penalty up to 200 crores are there. In the same way, non-fulfillment of the obligations of the significant data fiduciary, then penalty of 150 crores are there. So you can say there is huge numbers of penalties are there if you are not fulfilling the requirement. Now the question comes here, how as an individual or as an organization we will fulfill the requirement of this act, how we'll comply, because there is a huge numbers of penalties associated with that. So to to be complied with this regulation, what we need to understand first, we need to do first the first step. What we need to do, we need to identify the data flow. That if we are capturing any data within the organization, so we need to first identify the personal data flow within the organization, that how we are capturing the information and how the information we are sharing to the multiple stakeholders. The first thing what you need to do, a data flow diagram. Then second thing what we need to do, we need to do a DPIA, or you need to do a PRA, privacy risk assessment, a data processing impact assessment. These things we need to do. Now, once we have a proper risk with us, then we'll go to the controls. The third thing what you need to do, you need to give the privacy, you need to create a privacy policy of your organization. Then fourth thing, you need to give the privacy notice to the user, before collecting any personal information. You need to take the consent. You need to take the consent from the user before collecting any personal information at all. So these are the certain basic things what we need to do within our organization. Once we do have all these things, then we need to implement the privacy enhancing technology within organization, that is called as the privacy by design or privacy by default. The privacy by design and privacy by default related controls what you need to implement within your organizations. So there are, by having, because you need to have a proper IT controls within your organization, because your data should not be leaked, data should not be shared without having proper consent of the users. The proper IT controls should be implemented, that is called as the PET, your data data encryption, data pseudonymization, data anonymizations, related techniques what you can use, a proper access control system you can implement within your organization, so that data could not be accessed by multiple people. So within your organization, only those who are authorized to use that data, they will able to use. That there are multiple things what we need to have within the organization. And if you are sharing those data with any third party, in that case you should have a DPA with them, data processing agreement with your vendors. If you are sharing any personal data to any of your if any of organization for doing the further sub processings and all. So these are the basic things what we can do within our organization, we can implement in our organization to comply with these kinds of regulations. So that's all from today's video. Hope I am able to clear all your doubts or your query related to the personal data protection bill 2022. Thank you.